Welcome to California Bar Prep, your study companion for the California Bar exam. In this lesson, high-yield wills and succession core rules. Let's begin. High-yield wills and succession questions test changes, changed documents, changed family, changed property, and changed beneficiaries. California probate code rules determine whether those changes revoke, alter, save, or defeat gifts. Your answer should be relentlessly sequential: validity, revocation, components, contests, construction, distribution. California essays also test policy. Formalities protect against fraud, but harmless error protects intent. Anti-lapse protects family lines, but contrary intent controls. Omitted spouse and child statutes protect likely accidental omissions, but not intentional disinheritance or transfers outside the will. Explain those policies briefly when applying close facts. Undue influence. A will or gift may be invalid if undue influence overcame the testator's free will and caused the disposition. California analysis often considers vulnerability, influencer's apparent authority, actions or tactics, and equity of the result. A presumption may arise when a person in a confidential relationship actively participates in procuring the instrument and receives an undue benefit. Fraud. Fraud in the execution occurs when the testator is deceived about the nature of the document. Fraud in the inducement occurs when the testator knows it is a will, but is deceived about facts causing a particular disposition. Remedy may invalidate affected provisions or impose constructive trust. Duress and menace. A disposition caused by threat or coercion can be invalid. Analyze causation. Did the pressure produce the testamentary act? No contest clause. California enforces no contest clauses only within statutory limits, mainly certain direct contests brought without probable cause and specified creditor or property claims covered by the clause. Do not assume every challenge forfeits a gift. Omitted spouse. Testator executed testamentary instrument before marriage. Surviving spouse was not provided for in the instrument. Spouse may receive a statutory share unless an exception applies. Exceptions include intentional omission appearing from the instrument, provision by transfers outside the instrument intended in lieu of testamentary provision, or valid waiver. Share is generally drawn from estate property under statutory rules. Omitted child. Child born or adopted after execution may receive a statutory share, if omitted. Exceptions include intentional omission apparent from the instrument. Testator had other children and left substantially all estate to the other parent, or provided for child outside the will in lieu of testamentary gift. A child believed dead or unknown may also raise omitted child issues under probate code rules. Anti-lapse. If a beneficiary predeceases the testator, the gift usually lapses. California anti-lapse can save a gift to kindred of the testator or kindred of a surviving, deceased, or former spouse or domestic partner if the beneficiary leaves issue who survived the testator. Contrari intent defeats anti-lapse. Words of survivorship may show contrary intent depending on context. Ademption by extinction. A specific gift identifies particular property. The property is not in the estate at death. The gift is deemed unless an exception or replacement rule applies. General and demonstrative gifts are not deemed in the same way. California may protect beneficiaries in certain conservatorship, condemnation, insurance, or unpaid proceeds situations. Abatement. If estate assets are insufficient, gifts reduce in statutory order. Intestate property abates first, then residuary gifts, then general gifts, then specific gifts, subject to contrary intent and protected shares. Abatement is about shortage of assets, not disappearance of specifically gifted property. Capacity versus undue influence. Capacity asks whether the testator had sufficient mental ability. Undue influence asks whether another person overcame free will. A testator may have capacity, but still be unduly influenced. Dependent relative revocation. If testator revokes a will based on a mistaken belief that another disposition will be effective, the court may disregard the revocation if doing so better carries out intent. Apply only when the mistake and conditional nature of revocation are supported by facts. Revival. If a later will revokes an earlier will and the later will is then revoked, the earlier will is revived only if statutory intent requirements are met. Do not automatically revive the earlier document. Specific, general, demonstrative, and residuary gifts. Specific gifts are particular items. General gifts are payable from general estate assets. Demonstrative gifts are general gifts from a specified source. Residuary gifts take what remains. Classification controls ademption and abatement. A will contest can invalidate one provision without destroying the entire will if the problem affects only that gift. Suspicious circumstances do not equal undue influence unless linked to causation and unfair result. Anti-lapse applies only to covered relatives and requires surviving issue. A residuary beneficiary who predeceases may create partial intestacy unless anti-lapse or alternate taker applies. Divorce can revoke certain dispositions to a former spouse under probate code rules. Analyze effect on fiduciary nominations and gifts. Simultaneous death rules may affect whether a beneficiary is treated as surviving. For a contest, write separate mini-IRACS for capacity, undue influence, fraud, duress, and interested witness if facts support them. Do not merge them. If a caregiver or new partner procured a late life amendment, analyze confidential relationship, active participation, undue benefit, vulnerability, isolation, secrecy, and changed estate plan. Then state the remedy: invalidation of affected provision, constructive trust, or distribution under prior instrument or intestacy. For changed property, classify the gift. My 2020 Tesla is specific. If sold before death, ademption is likely unless unpaid proceeds or statutory exception applies. $100,000 from my brokerage account is demonstrative. If the account is low, it may be paid from general assets unless contrary intent appears. All the rest is residuary and absorbs failed gifts unless anti-lapse or other rules redirect them. For family changes, apply omitted spouse or child statutes before final distribution. If the will predates marriage or birth, ask whether omission was intentional, whether outside transfers were intended as substitutes, and whether waiver exists. Finally, distribute property. State who takes each gift, who takes residue, and whether intestacy applies. California, wills essays reward final accounting more than abstract doctrine. That's it for this lesson. Download California Bar Prep on the App Store for lessons on all 14 bar subjects, practice questions, and essay frameworks. Keep studying, and good luck on the bar exam.